Hello students, welcome to Legacy IAS Academy. Today we are going to discuss in this particular video about the recent crisis that is going on in the Maharashtra politics and what is the role of anti-defection law in this present crisis, and can anti-defection law can be applied or not. So let us try to understand the nitty-gritties of this particular issue. So first of all, the context in which we are discussing today's issues is because recently a political crisis has unfolded in Maharashtra and have thrown spotlight on the anti-defection law, what is the roles of speaker and deputy speaker, as well as what is the role of governor. So how the crisis began? It began when on the Wednesday, that is 22nd of June, the ruling Shiv Sena called a meeting of all its MLAs in Mumbai. However, some of its legislators were not able to attain meeting in Mumbai and aligned themselves with the party's rebel leader Eknath Shinde, and they are camping in Guwahati. The party has warned that the MLA who have been absent from the meeting, that they would be considered and presumed that they wanted to leave the political party, and that is why they have not attended the meeting. And thus, since they will be presumed to be leaving the political party, this would therefore lead to action against them under the anti-defection law. So that is the whole background of this particular crisis. So what is the anti-defection law? Let us try to understand about this briefly. So first of all, the anti-defection law was introduced by the 52nd Amendment Act of the Constitution and is inserted in the 10th schedule of the Constitution in year 1985. So what this law does? This law basically punishes any individual members of parliament or members of legislative assemblies if they try to leave one political party for another political party. And the main objective with which this law was designed is to bring stability to the governments by discouraging legislators from changing parties, because early in the 1970s and 80s, there is very normal procedure and practice where people change their political parties as they change their clothes. And that is why we have a very popular term at that time that is called as Ayaram and Gayaram. That means Gayaram was a politician from Haryana who changed political party so frequently, and that led to term of this particular point of this particular term. So basically, to prevent defection of individual MLAs or MPs from one political party on whose ticket they have been elected to some other political parties in mid-term, that was the main objective of this particular law. So what are the grounds of defection which can be considered as per this particular law? So total 4 provisions has been mentioned. The first provision is that if any member of parliament or member of legislative assembly wants to voluntarily give up membership of any political parties, they can be that can be one ground of defection. Second is if any MLA or MP is voting against the party direction, that is, party want them to vote on any particular issue in different manner, and they want to exercise their right to vote by their own individual thinking, or even if they do not participate in the voting procedure despite having a clear guideline from party, in that case defection can also be considered. The third is if any independent member, that means member of parliament or member of legislative assembly, if they has been elected as an independent candidate, if they join any political party after the election, they can also be considered as defecting from the as per the anti-defection law. And the last ground is for the nominated member. That means nominated member have to join any political party within 6 months. If they are joining a political party after the expiry of 6 months, then also that will be one valid ground of defection. However, there has been certain exception that was introduced by the 91st Constitutional Amendment Act of 2003 in this anti-defection law. So what are the exceptions? Exceptions are that if the member of parliament or MLAs who leave political party constitute 2/3 of party's strength in legislature, then anti-defection law will not apply to them. That means suppose if a political party has total 100 number of seats in the legislature, and if 2/3 of these 100 members want to leave the political party together, that means they are not defecting. It is considered as a valid ground of leaving the party, and they can join any political party or can create a political party of themselves as well. So these are the 4 grounds of defection, and this is the this exception. One other thing I want to point out, that earlier, before this 91st Constitutional Amendment Act of 2003, earlier if 1/3 of the strength of party's legislature want to defect, then in that case also anti-defection law did not apply. However, by the 91st Constitutional Amendment Act, 1/3 was changed to the 2/3 of total strength. So what has been the past cases as far as the defection is concerned? So in recent times, last year itself, in the case of Meghalaya, around 12 of the 17 Congress MLAs joined the All India Trinamool Congress, and they were under the exception of anti-defection law. Similarly, in 2019, all 6 MLAs of Bahujan Samaj Party in Rajasthan joined the Congress, and that also, since all 6 MLAs are joining, that means they can also not be considered under the anti-defection law. Exceptions law will apply. And similarly, in the same year, 4 out of 6 Telugu Desam Raj Sabha MPs have joined the BJP, and that is why exception clause of the anti-defection law also applies here. So these are some of the past cases where, despite defecting from a party, they were not penalized under ADL because of the exception clause. So how does it undermine representative and parliamentary democracy? Because every elected MPs from any political party, they cannot vote or they cannot take part in proceedings of parliament, or they cannot convene some their own thoughts, individual thoughts, because they are bound by the political party's mandate. That means even if they want to vote against their own parent political party, they cannot do so. And that is why it undermines the representative and parliamentary democracy. Second, there is also a criticism about controversial role of a speaker. Because many times, since the speakers are generally elected from we can say ruling parties, both at the center as well as state government, so speakers are generally considered to be biased toward their political party, and that is why many times they do not take steps or they do not take decision very fast and under the anti-defection law. And that is why we have incidences where the defection law, under anti-defection law, the members have been removed or members have been penalized, somewhere ranging from 3 months all the way going up to 1 year, 2 years, or even 3 years. As per the Supreme Court recommendation, it has recommended that the speaker has to take action under anti-defection law within the period of 3 months. However, many times this is not followed. Similarly, the criticism also is that only wholesale defection is allowed, while retail defection is penalized under anti-defection law. And that is why both should be penalized equally. That is also one viewpoint. Not only that, even Election Commission of India has said that allowing a speaker to take decision as far as the anti-defection law is concerned is kind of not free of bias, and that is why it is Election Commission of India that should be given the right to take decision under anti-defection law. So these are few of the criticism of this particular law. Now question comes that the exception given as per the 91st Amendment Act of 2003 in the anti-defection law, can it be applied in the current scenario? So first of all, as per the 2/3 strength law, they require 55 MLAs to exit the party, then only this law can apply. However, as far as the Eknath Shinde is concerned, he had support of only 30 MLAs, and that is why there can be no protection under the anti-defection law unless and until he is able to we can say he is able to gain majority of support of 55 MLAs. And after this, the assembly speaker will finally decide whether an MLA has left a party or group that constitute 2/3 of a party or not. So how can we see the process unfolding in coming days if the crisis does not end? So first of all, any member of legislative assembly can petition a deputy speaker that certain MLAs have defected from their political parties. Now, why deputy speaker? Because as of now, the position of a speaker in the Maharashtra Legislative Assembly is vacant, and as per the Article 180 Clause 1 of the Constitution of India, if the speaker's post is vacant, it is the deputy speaker that has to discharge their duties as a speaker. So that is why MLA have to petition right now to the deputy speaker. Then once the petition has been filed by the MLAs, the deputy speaker would then forward the petition to the MLAs against whom their colleagues are making the charge of defection. So in this particular case, the 30 MLAs who are supporting the rebel leader Eknath Shinde, they will be it is to them the deputy speaker will forward the petition, and then these MLAs will have 7 days time window in which they will have to reply against this particular petition. After listening to the reply of these MLAs and also from the other MLAs, the speaker will finally decide the matter after hearing all the parties, which could take time. And as we discussed before, time is not fixed. It is the speaker's discretion that when he decides on the anti-defection law. So what is the role of governor in this particular case? As it is a situation which can lead to political instability in the state, earlier governors and even now governor used to play a very crucial role. However, before 1994, governors used to take a very simple step. They say that there is a political instability in the state, there is a political crisis in the state, and they used to impose the president's rule. However, after 1994, since the SR Bombay case, that power of governor has to a large extent been curtailed. In the SR Bombay case, Supreme Court has clearly noted that whether there is a political instability in case or whether the ruling party have lost confidence in the legislative assembly, it has not to be decided by the governor, but it has to be decided on the floor of the house. And that is why what can be done by the governor, which is currently Bhagat Singh Koshyari, he can ask Chief Minister Uddhav Thackeray to convene the assembly. And after convening the assembly, the Uddhav Thackeray will have to prove his majority on the floor of the house. And if he is able to do so, then the government will function. However, if he fails to do so, then of course there will be a recourse to President's rules or some other alternatives can be found out. Apart from this, what are the other possible outcomes? One other possible outcome lies with the state government currently. The CM of his state can recommend dissolution of the assembly to the governor. This can be done even before the completion of the 5-year term of the legislative assembly and call for a fresh, new, early elections. However, whether this will be allowed or not, it totally depends on the governor's discretion, and that is when the governor will decide that whether they can dissolve the assembly before or whether a new alternative party can come into the power in the state. So that is all for this particular issue. I hope you understood about that what is or why this crisis is going on. Thank you very much.